I'd like, therefore, to take this opportunity to invite the Honorable the Chief Justice Ladit to come and make your remarks at this point in time. And Apoyo, I thank you very much.
My lords, I hope I'm doing the right thing. My lords, Justice Remy Kasule and Geoffrey Kiriabwire of the Court of Appeal, Constitutional Court. My Lord, Lady Justice Jane Francis Abodo, Director of Public Prosecutions. Your Excellency, Roswitha Kremser, Head of Office Austria. I think I got it almost right. Oh, good. I'm glad to hear that. Your Excellency Mariam Black, Uganda's ambassador to the European Union, and my friend, although I failed to recognize you because of, yes, until when you undressed your mouth. Honorable members of Parliament, Honorable Leandro Komakech for Gulu Municipality, Honorable Veronica Bichetero for Kaberamaido District. Come again? Oh, Kaberamaido. Ah, you didn't go through the. Oh, that's very good. We should congratulate her for tussling not just with men, but tussling with everybody else and triumphing. Dr. Sylvia Namubiro, CEO of Last Minute. Rachel Odoi, Senior Technical Advisor, JALOS, representatives of the JALOS institutions here, the Chairperson Board of Last Minute, members of the civil society present, the media, innovators and partners, distinguished participants, ladies and gentlemen. It is my honor and privilege to address you today during the occasion of the second Legal Aid Conference 2020. I am grateful to the organizers, the Legal Aid Service Providers Network, the innovators and partners for picking me for invitation to speak to you and open the showcasing of innovations today. I am delighted that despite the current situation presented by COVID-19, we are able to meet under the new normal and deliberate on ways to enhance access to justice and devise strategies to improve on the administration of justice in Uganda. My delight for this opportunity to speak to and with you arises from the fact that upon being tasked with the responsibility to head the judiciary of Uganda, I picked on access to justice as my signature theme and pursuit for the duration that I'll be in charge of the judiciary of Uganda. And it will not just be the old narrative, the physical access. It will be more importantly, the procedural and real factors that enables the people for whom we hold these offices to access justice. Justice is meaningless It remains a textbook provision, or remains a legislative or even constitutional provision if our people cannot realize their rights effectively through the courts of law, if they cannot resolve their disputes effectively through the courts of law, if physically they cannot access institutions of dispute resolution, if the means that would enable them effectively realize those aspirations are not in place. And this is really why I thought being invited to speak to you and share with you is of great delight to me, because it also enables me to access the means by which we can allow our people access justice. I am informed that this conference is the second of its kind, and that the inaugural Legal and Aid Innovations Conference was held in 2017. I thank the organizers and the legal aid providers for making this an annual event and enabling us to reconvene and to take stock of what has worked and lessons learned during the period preceding the conference, and where we desire to be as a people and country. I note that the theme for this conference is exploring new innovative approaches for enhancing access to justice and legal aid amidst the COVID-19 pandemic. To me, this highlights our needs during the current situation presented by COVID-19 pandemic. Against normal service delivery processes, I believe that continuous innovations to ensure access to justice and legal aid is core to effective administration of justice in Uganda. For this noble innovation to establish itself, there must be in place an enabling environment to allow its reception and implementation. The courts of law and other jealous actors have to support and embrace innovations and technology in order to meet the vast needs of the growing population and to withstand the effects of COVID-19. We will only be able to achieve Sustainable Development Goals, SDG 16, where there is constant innovations and exploration of possibilities for better services. Advancing with innovations helps us to mitigate gaps in information sharing and expedites judicial processes with increased ripple or multiplier effects on the development of the country. With the recently enacted Administration of Judiciary Act, which was done this year, 2020, in place, the judiciary welcomes contributions from stakeholders as envisaged under Section 2B, E, and C thereof. This, according to the law, is intended to facilitate the improvement of the efficiency and effectiveness of the courts of judicature, to streamline the administration of the courts, and to facilitate a judicial process that is committed to the expeditious determination or resolution of disputes. The justice sector, like other sectors, has been struck by the COVID-19 pandemic. Needless to say, following the closure of courts of law as one of the requisite and inevitable mechanisms to contain the spread of the deadly COVID-19 pandemic, court operations were severely curtailed. The closure and scaling down of court operations affected the right to fair and speedy hearing for many suspects who remained in custody beyond the 48-hour mandatory period before being produced in courts of law. This adverse effect notwithstanding, the judiciary fairly remained afloat through adopting innovative approaches to continue with hearing of cases. We had to scale down operations of courts, yes, but had a skeleton staff of judicial officers, whereas on the other hand, lawyers were considered non-essential. Therefore, we resorted to the use of innovations, including virtual hearings and online service delivery mechanisms, including delivery of judgments. Such innovations include the use of video conferencing and Zoom. The use of ICT within the judiciary is anchored under legal notice number 6 of 2019, Section 5 of the Constitution, integration of ICT into the adjudication processes for courts of judicature, Practice Direction 2019. As an institution, the judiciary is implementing electronic court case management information system, notoriously known as ECMIS. ECMIS is a fully featured system which automates and tracks all aspects of court processes of a case life cycle from initial filing through disposition and appeal. The system also has an advanced analytical reporting mechanism to simplify the legal understanding of cases. This system, once rolled out fully, will contribute to reduction of corrupt practices through eliminating human interaction in handling case files. We will continue to advance all reforms towards increased innovations and access to the courts and information. During the current situation of COVID-19, we have witnessed increased innovations in legal aid service provision. Actors have used megaphones, as we were told, moving vans, and situational room responding to access to justice issues. Similarly, in the judiciary, we welcome innovations and we embrace plea bargaining, radio talk shows, scientific sessions, small claims procedure, and mandatory mediation, which is anchored under the Judicature Mediation Rules 2013. This is number 10 of 2013. On that note, I would like to appreciate the organizers of this conference for articulating the concept of innovation and not only limit themselves to tech-based innovations, but also promoting innovations regarding informal dispute resolution. Let me say this, because of the place legal aid plays in access to justice, it is my very humble view, which I hold strongly though, that legal aid should not just be about representing the underprivileged in court, but it should equally emphasize advisory legal roles. It should be thinking of carrying out outreaches, educating our people to know what their rights are, what the law is, on many aspects. I say this because Whenever I go home, average twice a month, could be more depending on what is up. The moment they see my convoy, and these days I can never travel secretly, which is really unfortunate for me. The moment my convoy announces my presence, if I arrive around midday, around lunchtime, by 4 o'clock to 6, I have a crowd. You know, my compound becomes a law firm. That's really what happens. And I believe my lords suffer the same problem. Whenever you go home, they come, I have this case. Many think I can talk to a magistrate to resolve. But many come and say, my case has taken 5 years. That is my responsibility to find out why would a case take that long? Many, you know, I had to gather my witnesses. We arrived late, the case was dismissed. Many of these are problems of access to justice. And as I said in my interview, I think my village in the Acholi sub-region, my own village where I grew up and where I live, is 160 kilometers from Gulu High Court. If you want to understand, it's like going to Jinja and coming back to Kampala to reach the High Court. Either you're going there on appeal or the subject matter is for the High Court. And there are no buses plying the route between that one. So there are these private taxis. And at times they have to travel on border. You can imagine traveling on border from here up to Jinja and back to Kampala. That is still one way. And then you must bring your 5 witnesses. Or if you get a truck, a businessman's truck, then you come. And then there are no law firms in the whole district. There are no law firms. The lawyers who go to the grade 1 court, which serves an area which is 4,000 square kilometers, are visiting lawyers. In a situation like this, there is justification for providing both physical access, narrowing the distance. And before I go there, by the way, the extreme end of my district, which borders Karamoja sub-region, Francis Abode's sub-region, you travel 200 kilometers. I think that is somewhere like from here to Tororo to get a high court. So we must cater for the physical access, but we must also cater for the legal minds that will help the people access that justice meaningfully. So we really have our work cut out for us. And this is why this innovation we're coming up with is important. This is why legal aid is a strong component of the justice mechanism that we're speaking about. I wish to inform all the development partners, JLOS actors, legal aid service providers, and innovators that innovating in the justice sector has been the greatest of lessons learned during the total lockdown under the COVID-19 period. Justice institutions should therefore plan effectively and earmark sufficient budgets for innovations if we are to effectively deliver on our mandate under the new normal. On that note, I welcome all actors to join the government of Uganda and the judiciary in strengthening administration of justice in the country. It is commendable to recognize and appreciate those who have ventured into innovations and to protect their works as motivation for further development in this area. I am confident that appreciating those who have excelled in innovations in an event like this one begets more innovations, which in the long run helps to propel us into success. I am reminded of the fact that many great nations, and especially those we currently call the Asian tigers have been successful in innovations in many areas of service delivery, including the administration of justice, because of consistency in innovations. We too in Uganda have our lessons and challenges to inform our innovations. However, our innovations are confronted by challenges, limited resources, funding, and those related to administration of justice. Access to justice is still impeded by insidious factors, especially on the supply side. The Hague Institute for International Law, HIL, in 2016 conducted a research which revealed that 80% of Ugandans cannot afford services of a lawyer. 80%. And only 5% trust the formal justice dispute resolution mechanism. 5% of the people of Uganda have confidence or can trust our justice mechanism. Now, I have just been talking about the person who files a case and has to wait 5-8 years before the dispute is resolved. Many times that dispute has been overtaken by events. Many times the person with a good case has lost half or has lost the vital witnesses, and so on and so forth. Then they go to the Court of Appeal, another 4 years, because what I've just told you. I have one judge in Gulu, I have one judge in Soroti, and that one takes care of the traditional Teso district and the whole of Karamoja. That distance is even worse than the one, my experience as I gave you, because the judge sitting in Soroti has to take care of Kabong. I do not have I didn't care to find out what the distance. It is probably twice my distance to Gulu. And such a person comes with 8 witnesses to Soroti, and the judge is not available for genuine reasons. He's indisposed, he's sick, has been called to Kampala, for whatever reason, and the person goes back. Such great expenses. Another time, and the case can only be adjourned beyond 12 months. And yet the judge works 7 days a week. 5 days is religiously in court. Then he or she has no weekend because he must write a judgment on Saturdays and Sundays. And then the person who comes from Kabong, or Kotido, or Nakapiripirit, has no access to lawyers. Even if the lawyers were available, does not have the economic means or capacity to retain the services of a lawyer. What more do we need to speak for the importance of legal aid in this country? And what I've told you can be replicated everywhere in Uganda, including within 12 kilometers of Kampala. So when I stand before you, I commend you, and I commend you with justification. The challenges are big, but I see that the focus, I see that you've diagnosed where the problem is. And I call on our development partners. This is where you should sink your taxpayers' money to enable our people to access justice. I would be very happy to know that right from the grade 1 magistrate courts in this country, wherever there's a grade 1 magistrate court, we have got legal aiders who help our people. You know what happens? What I discovered? The ordinary man in the village now goes to a clerk of the magistrate to prepare these pleadings because we are stuck with this adversarial system of pleadings or of litigation. If there was a legal aid office properly funded, where you have some 2 lawyers look at the dispute, say, you know what? You have no case. Why don't you go and sit down and mediate? Why don't you allow, if it's a dispute over land, why don't you allow the elders, the traditional institutions, to mediate between the 2 of you? If we had these institutions in place, it would enormously contribute to access to justice, resulting in harmony in society, and the end result is development, socio-economic development, because then people can focus on the things that would lift their status in life, instead of being locked over a land dispute for 12 years, for 15 years. You are not using that land because the magistrate imposes an order of injunction. For 12 years, that land nobody's using. You can imagine if that land is released. And if I could ask a survey to be done. What is the size of land that is in dispute in our courts all over the country? I think, my Lord Geoffrey, we can establish that. And then translate it into loss of economic opportunity. That's really what we are talking about here today, on the importance of access to justice by our people and the role legal aid can play in unlocking what otherwise is a fetter on our economic development. So confronting this reality of the laughable percentage of our people who can enjoy justice, confronting this reality and other challenges, such as limited number of judicial officers. I've just said I have about 60 High Court judges in a population of over 40 million now. I think the projection puts it at slightly, about 45 million, I think. Those of you who are good at mathematics can work out. I mean, a single judge takes care of how many Ugandans? 60. For areas that are lucky, you have one grade 1 magistrate in a district. Ordinarily, every district must have a grade 1 magistrate, a minimum of one grade 1 magistrate. Whenever we create districts, we must also simultaneously have in place a grade 1 court. The way the creation of a district automatically has veterinary doctor, a health center with a doctor or doctors, agricultural or environmental officer, name it. The way we have these civil servants at sub-county level is what we must strive to achieve. The lowest level for judicial officers is now the grade 1 magistrate. When I was growing up, the grade 2 magistrates courts were at the sub-county level. There was more semblance of the presence of the courts of judicature then than now. And there was a much smaller population than what we have. I remember in 1969, we were like 9 million people. Today, we are 45. We will strive, we will fight first to fill the 82 numbers of judges of the High Court, which Parliament has resolved. Yes, a judge must handle cases between 600 and 70. It is humanly impossible to finish those cases. And that's when you hear about backlog in the courts of law. That there are over 10,000 cases, there are over 30,000 cases in various courts of judicature, the Magistrates Court, the High Court, the Court of Appeal, and Supreme Court. Because it is humanly impossible. And that's why for us, we say if a case has taken 2 years, then it is backlog. My predecessor, Honorable Justice Bartka Turebe, Chief Justice Emeritus now, traveled to Malaysia about 3 years ago. I think you were in his company, my lord. So he met his colleague, the Chief Justice of Malaysia, was looking for best practices. So the Chief Justice of Malaysia tells him, oh, for me, if a case has taken 8 months in court, it is a matter of concern. The judiciary administration's radar is alerted. The sensors begin now waving red. A case has taken more than 8 months. Why? So my brother asked him, how do you do it? Oh, I've done it because for a population of 30 million, when Uganda was 40 million, for them they were 30 million then. For a population of 30 million, I have 150 judges of the High Court alone, 150. Not mentioning magistrates who are in thousands, not mentioning the appellate courts. Then my brother nods and says, I now understand. He says, how about you? So he says, for me, I have 58 judges of the High Court. What is your population? My population is more than yours by 10 million. Oh, you're 40. How do you do it? So now my brother was asked, how do you do it? Then he sheepishly says, you know, that is why for me, backlog begins from 2 years. And the other one says, 2 years? So my brothers and sisters, I welcome all forms of innovations. But even with innovations, we can only do so much. I said it in my interview. And for me, I have been to all the three arms of government. I've been a member of parliament. I was privileged to be part of the group that wrote the constitution, which is in place now. I've been in government, part of the executive, and now I'm spending the final phase in the judiciary. Then I go and the circuit will be complete. I will now go back to where I grew up and be woken up by birds. If the people of Uganda do not task the executive and parliament to ensure there is a paradigm shift, to have a mindset change, I will leave this office of being Chief Justice of Uganda when backlogs have not only failed to reduce, but will have heightened. We must ask for the other arms of government to strengthen the judiciary of Uganda to be able to render justice to our people. For me, that's the beginning point. It is from a robust judiciary in terms of people who are given the weapons, the instruments with which to render justice, that we can now fit in legal aid, technological advancement. And then, if I had like 120 High Court judges, slightly more chief magistrates, because we intend to scale up the level of their jurisdiction. Some of the things that come to the High Court will, hopefully in the near future, will be handled by chief magistrates. And then we up the numbers of grade 1 magistrates, where a district has a minimum statutory minimum of 2 magistrates flung on different ends of the district. Then I will be able to say with pride, if you file your suit in the High Court, because then let me use my Acholi sub-region, just not because I'm an Acholi, but I am familiar with the terrain. We have a minimum of 2 High Court, two High Court establishments. The one in Gulu, another one in Kitgum, which would reduce the distance from 160 to about 100, in my case. And then I have a couple of judges in Gulu. I have a couple of judges in Kitgum. I will task the judicial officers to explain why a case has gone beyond 1 year in their court. Because then all these judicial officers should have research assistants. You go to court, you have an understanding from the pleadings, and your understanding of the law has been augmented by research work. Conduct a hearing, and other than give you 2 months to write a judgment, the judgment should be out in 1 month. And instead of having 12 or the maximum of 15 justices of the Court of Appeal, if I had twice that number, 30, there's no reason why an appeal should take up to 1 year in court. You resolve the matter after waiting 8 years, you wait another 5 years in the Court of Appeal or even more, those who would fight. And the technological means by which now we render justice would strengthen that. So this is my plea to the two arms of government. This is my plea to the people of Uganda who deserve justice, that you must task. These are the questions you should ask your government. These are the questions you should ask your representation. When they come to stand, among the questions you should ask people who are contesting for parliament, what will you do so that we can access justice? So I know that this challenges we are confronted with. Number of judicial officers, limited budgetary allocation to the institution, which should have been delivered to justice happens. We need people who will complement our efforts, because power belongs to the people. We do it, we exercise it in the name of the people and for them. It is therefore my commitment to support proper innovations and strategies. Together, we shall overcome the current challenges in the administration of justice. It requires innovative minds and proactive individuals. I am confident we are on the right track, given the steps we are taking towards harnessing technology to leverage service delivery in Uganda. Stephen Jeffs, a renowned marketing and business expert, I have never met him. He's an expert of the Q Group, reminds us of what our targets should be. He had this to say, in quotes, "Innovation is the unrelenting drive to break the status quo and develop anew where few have dared to go," close quote. If you're not prepared to go into the unknown, if you're not prepared to invest, if you're not prepared to take up new challenges, of course you cannot develop. So it's same with technology. I once again thank the organizers of this event and appreciate them for the collaboration in coming up with this conference. I applaud all partners, especially the Democratic Governance Facility, DGF, and the innovators for taking up this initiative to enhance access to justice through innovations. I also thank all the participants for attending this conference and wish you fruitful deliberations. I thank you all. I've said this for God and my country.